mentioned it, agreed for Saturday, that's why.
No, it was mentioned for today. It was mentioned for today. It was showing for today. Now it is showing for tomorrow. If it can be Monday, my lord, instead of
Monday or Tuesday, maybe. We'll see.
Monday.
May I have your lordship's
Can I-
permission to mention? Lord, I am seeking permission to circulate one appeal against the order of APTEL for tomorrow. So there is some urgency. It's an extraordinary order passed. And I would really, my lord, request that, my lord, the Chief Justice of India examines what is happening. my lords. Because I inquired and
Support the view. I'm for the state discom. Because today what is happening in a matter is that we will be practically shut out under the Prapti portal from either accessing electricity or taking electricity from other states for a so-called non-compliance, whereas the Supreme Court in that matter remanded us back in the matter and asked us to deposit an amount which we have deposited.
Well,
And
this
we've
is
been
very
told to
unfortunate.
can't
All
even
wrong
file a
facts
review.
are being given to your lordships. All wrong facts. The regulator, Mr. Mehta, after passing an order, comes to the appellate court and says, I passed the wrong order. It's a complete regulatory
I
capture
am
by the
right now
government.
requesting for tomorrow. I'll have to satisfy your lordships.
All right,
His
tomorrow.
argument is that I
Tomorrow.
passed an order, it's a wrong order.
Yes.
All right, we will hear.
Cannot
both
be
sides.
that.
We'll hear both sides.
Kindly have it on Monday,
Lordship's
Malak,
permission to
Monday.
mention a matter, Lordship's permission to mention a matter. This pertains to the recent elections that have taken place, Your Lordship. As regards counting is concerned,
Recent direction.
the elections of SCBA, Your Lordships. As regards counting is concerned, in fact, a few of the lawyers have actually tick mark rather than putting an X. So that's, let's say, if at all, if that can be considered, we've made, let's say, representation to the election committee that is there.
Not require our permission, please go and approach the election committee.
We've approached, there's five,
Mention an item.
there are 5 representations that have been given, Your Lordships, which has not been considered. Now, ultimately, it's the intention of the voter. In fact, let's say they've tick mark rather than actually putting an X. For example, let's say there are a couple of candidates were basically losing out on that difference of votes itself.
I am one of the candidates.
We would like to refrain ourselves to the extent possible from this election business. You please go and approach your election committee. There is
We have
senior
already,
5 senior advocates are there.
we have already approached, that is refused by the election committee.
Lordship, we have given representation, there are difference of counting by the volunteers and the candidate. So, and they are not taking any action. We have given representation, Your Lordship. I am requesting for the recounting of the, by the registry. What last year happened, same thing is happening this year also, Your Lordship.
Lordship, right tick is always allowed, Lordship.
Last year, the counting work has to be assigned to the officers of this court. That's why
Please, Your Lordship, same thing. I am requesting for the interest of the justice, Your Lordship,
declaration of result, nothing can be done.
and fair and transparency.
Right tick be allowed, well, because of that I am losing the election, Lordship. Right tick. I am only losing by 20 votes, Lordship, for the joint treasurer.
We'll see. I will at the best request the election commission to look into it. That's all. On administrative side, nothing on.
Because ultimately, it's the intention of the voter.
Regarding violation of my human rights by the
Madam,
registry,
cancel.
I mentioned the matter before Your Lordship on 25th of May. Your Lordship assured me of looking into it personally. But till today, my lord, I am being harassed in all the cases, my lord. In almost all the cases, I am being harassed. For example, my lord, one case, the diary number 19320 through 328 of 2026, it was declared by the registry that the defect has been removed on 18th of June 2026. And it was listed on 14th of August 2026, even after visiting to the registrar, my lord. They are asking us to go from this window to that window, my lord. There is a very bad culture in Supreme Court of India that file and run. Only those advocates will get relief through the registry.
Instead of please mentioning here, you could at least give me a complaint in writing.
My lord, I am complaining for the last 6 months, my lord. Nobody is listening.
No, complaining to whom? You have not sent any complaint to me.
My lord, by 4 letters, my lord. It is there in the email also, my lord. If I am going to the Secretary General, instead of listening to me, he simply used to make a phone call to the registrar.
First of all, Secretary General has no interference in, and that is not the responsibility assigned to him.
And the same thing happens with the registrar, my lord.
You are a member
There are
of-
2 registrars sitting over
Tell
there.
me, you are a member of the bar.
Yes, my lord.
Here is not a chief justice, is not accessible. People meet me every day. You could meet me, you could send me a representative.
Today only I would like to meet, my lord. Please allow me.
I can't promise for today, but then you should have at least.
My lord, I have written letter and the letter is with me. The complaints are with me, or I have already sent all the complaints to email to the Secretary General, to the Supreme Court of India also. Hard copy.
To me, at least one complaint you could give to my office.
Okay, my lord.
You know very well where my PPS sits, where my other staff sits. You could hand over it.
Yes, my lord.
I
Please,
would have
my lord.
examined it.
We are really feeling very harassed, my lord. It seems that for poor advocates like me, there is no space in Supreme Court
There
of
is
India,
no
my lord.
question of advocate being poor or rich. The advocate, every advocate
Really, my lord,
has to
if I
respect
don't
the-
have the resources, I am not allowed
Well, you
my
are a-
file to be reached to the court, my lord.
You are messenger of the cause of justice. Therefore, everybody should be treated with.
Yes, my lord, but it is not happening in the court, my lord.
Please, your lordship.
My lordship, some direction, your lordship. Sorry to actually mention it again, your lordship. Some direction because
No,
otherwise the list will be.
no question of any direction.
Mentioned
Thank you.
Right click be allowed.
Your lordships, they are showing for 24th. I'm praying for not to be late. Two connected contempt petitions in violations of a 20th Jan order of this court. This is in relation to a service matter of grade 3 teachers in Rajasthan. And we are praying that the matter be listed on Monday. It's showing for 24th. I'm praying for not to be deleted.
See, on Monday, there is already lot of rush.
Your
Your lordships, my
We
content
mentioned
petition
it
is
from
also.
last week, we were told it'd be listed on Friday, now it's showing for Monday. I'm just praying for not to be deleted on these two matters. The MAs are already listed. We're praying for the contempts to be listed as well. The orders are from 20th Jan and there are about 160 petitioners in this and many more that may file.
Maybe 160. How does it matter? How many?
Your lordships, I'm just praying for not to be deleted on Monday. It's already showing on
Is it
Monday.
already listed?
It's not listed. It's supplementary is yet to come. I'm just praying for not to be deleted. It's showing on computer generated date of 24th.
Only when the matter is listed.
Lords, may I mention, Lords?
But it's not there.
Okay.
Lords, may I?
Your lordships, my content petition is also arising out of the same impugned order, your lordships. It was directed to be listed on 17th, your lordships. I'm also requesting that it may be taken up on 24th only.
Contempts rising of what?
Your lordships, it's arising out of an impugned order wherein the recruitment of teachers of 2012, the court directed, honorable court directed that they may be given appointment in pursuance of the order, your lordships, within 2 months, but the said exercise has not been done, your lordships.
See, contempt, there is no urgency in contempt.
Lords, may I mention?
Listing of.
Lords, this is.
Grateful, your lordships.
Milords, may I mention a demolition matter, Milords? I'm sorry. Mention a demolition matter, Milords. It's an ongoing matter, Milords, where we were not a party, Milords, and orders have been passed. This is a special bench of Justice Pardiwala and KV Vishwanathan taking up matters, Milords. We have moved intervention applications. We had mentioned this matter before your lordships on the 10th, Milords. Your lordship said that this may be listed, but Milords, it has not come up, Milords. Therefore, Milords, the order, Milords, may I just pass on the orders? The orders say that within 6 weeks, everything will be demolished, Milords. Now, Milords, ours was a case where writ petitions were filed in the High Court. We have been granted protections. So, factually, Milords, we are better off and we need to show it to the court.
Can't understand. The order has been passed by whom?
Milords, Justice Pardiwala's order. It's a special bench, Milords.
The Supreme Court has passed an order of demolition. Then what the High Court business is there?
No, Milords. These are writ petitions which were pending since years, Milords, and where a status quo was granted. This is an order under an PIL, Milords, where we were not even a party, Milords. Now 63 applicants along with others have come, Milords.
You are an unauthorized occupant. What can be
No,
done?
Milords, we are not.
If
Milords,
you are not, then please go to the bench.
yes, Milords. Therefore, Milords, I'm only saying my intervention applications with directions application may be listed and heard, Milords. Milords, that 6 weeks will get expired by the 1st, Milords, and therefore I'm only listing that this may be listed, Milords.
For Justice Pardiwala, because I think.
Milords, we have already done that, Milords, but he's saying that let it come when the main matters coming up, Milords. That will happen in the 23rd of September, Milords. By that time, everything will be demolished, Milords. Therefore, Milords, let my applications be at least be listed, Milords, for consideration.
Lord, I am
Go and
seeking.
make a mention.
I'm seeking listing of Lord 3 criminal
Obliged.
SLPs on Monday or Tuesday, my Lord. The High Court has granted me anticipatory bail, but one of the condition is a cash deposit of 1 crore. Lord, I am requesting, Lord, that matter be kept on Monday, Tuesday. My challenge is only to the conditions, my Lord. The 28th, the order lapses, my Lord. If I don't. Grateful.
Millets, may I mention a matter, Millets? It's an election petition, Millets, where I am a Nagar Adhyaksh, Millets. I have been removed without following due process. Millets, on 28th, they have notified re-election, Millets. Kindly, on 28th, Millets, they have notified re-election for selection of new Adhyaksh. So kindly, Millets,
Election to the post of what?
to the post of Nagar Adhyaksh, Millets, in Maharashtra,
In Maharashtra.
President.
And what happened in High Court?
Millets, they have found that Millets, we have not been heard, Millets. while the process was continuing,
High Court has dismissed your petition.
High Court had dismissed our petition.
So that there is something wrong with your election, huh?
Minutes, kindly minutes, it may be.
Anyway, we will.
I am beseeching your lordship's indulgence to mention one civil appeal, my lord, in which date was fixed, my lord, and the matter was showing in the daily list, my lord. But now it is nowhere in the list, my lord.
Where it must be lying in the store in Supreme Court.
No, an early date was fixed, my lord, and the matter was showing in the cause list, my lord.
We will see.
Please, my lord, kindly.
My lords, I apologize for the unlisted mentioning. There was a tender condition that I had challenged. The High Court calls the tender condition as anomalous, but then the High Court goes on to say that the tender condition, the anomaly has to be rectified only for future tenders.
Tell a ground of urgency, not.
My lords, the High Court in the same order, the High Court in the same order says that release the bids immediately. The High Court in the same order says, my lords, that the bids should be released immediately. My lords, it's yesterday's order. We filed it yesterday night. My lords may either have it on Monday or Saturday. If the bid is released, then then the matter would become infructuous.
Oh, we will examine it. Give us the paper. Where
Grateful. Grateful.
give us the.
Lordship, Lordship, I just want to mention in a matter, I want to file rejoinder, just permit, Lordship.
Item 1.
Defects have to be cured also. Defects will have to be cured also.
Yes, my lord.
Defects have.
They are lying in defects.
It's in defects, my lord.
To cure the defects.
Subject to curing of defects, my lords, it may be listed. Grateful.
Lord, item 1, it's 812. This is that liquor scam. 7 people are already on leave, including the principal man, Anwar Debar. He's on interim bail by your lordship's court, and kindly see him.
Malas, I appear for the statements. Give us
Charge sheet is
2 weeks'
filed.
time, Malas. Malas, it's not the liquor scam, it's the manpower scam, Malas.
Everyone is on bail. For 2 weeks will you?
No, Malas, there's some of the accused who are still in custody, Malas, including.
He is one of the commission agents.
Absolutely, Malas.
Only 6 crores in that 1,000 crore scam.
Malas, this is 120, 180 crore scam.
Iver is on bail. What is that?
Bole.
He is not the main accused.
Malas, he's one of the manpower agents, Malas.
Manpower, not manpower.
He was providing the manpower, Malas.
Lord, this came under 66(2). Nothing has happened in the ED.
He had 34 crores was routed to, was
In my email.
34 crores of inflated bills.
It's only bail, Lord. Charge sheet is filed.
So notice the reply if any we file. Post the matter on so should be. Meanwhile, the petition is directed to be released on interim bail. Subject to such conditions as may be imposed by the trial court, including that. Pहले क्या था हमने that he will stay outside the state of Chhattisgarh.
He's not a public servant.
He's not
a public.
He's
not a public servant.
Director of a company, his signature was, and email was.
Signatory.
Email and phone number. Obliged. Grateful.
Well, item 2.
Petitioner in this matter, my lord.
Only a
Pursuant
minute.
to order-
Only a minute. Item 2, my lord, we have prepared a note, but I feel it should be by way of an affidavit. That is number 1. Lord, I am requesting for Monday. There is something in my mind. I'll discuss with the government and report it to your lordship's by.
Solicitor, you said that there will be some oversight committee looking into these difficulties, teething problem of introduction of the on-screen.
Yes, ma'am. There was a one-man committee, but my lord, there is something, my lord, before discussing with the government may not be, my lord, proper for me to, my lord, right now point out.
Grievance redressal mechanism wherever there is.
There was a window open for 1 week that whoever has some difficulty, they can come, they applied, and I think there are lots of, my lord, few thousand or few lakhs came and their grievances were redressed, my lord.
Some
1.68 lakh students, they came and their answer sheets were revalued. Yes, sir.
there would be a permanent.
A kind of a mechanism.
May I just make my submissions, my lord? As far as grievances are concerned, there are a lot of students more than that. Now, as I've made my submission even on last occasion, that now some of the students have cleared some entrance exams and they have not been able to score well in the CBSE's minimum marks which are required. So my lord, that is still pending. So I would request my learned friend to even look into it because a lot of students are there, their career is at hold, the courses have started. So I may humbly request the government and my learned friend and this honorable court to look into this. Almost near about 3 lakh students have appeared for the compartment exams. So there are more students who needs evaluation, who have not been
Look,
checked, who have
what,
not even
what
received
has
their
happened is
answer sheet. So my lord, these
finding
all
this-
may be looked into.
finding discrepancies, a specific decision was taken that for 1 week, we will open the portal, you give your grievances, your answer sheets will be re-evaluated. So 1.68 lakh candidates exercise that right within that 7 days period. Now, my lord, possibly what they are seeking is that give us grace marks. No, that may perhaps not be possible.
Mark is not possible.
Papers were not evaluated. Some
Grace
papers
possible. Re-evaluation or on-screen marks glitches.
That is done. That part, I'll place it on record. For 1 full week, that opportunity was given and 1.68 lakh students availed that opportunity.
My lord,
And they were re-evaluated and my lord, the results.
my lord, the number is very huge. A week's time is very less, my lord. There are a lot of students who are not having any access to the internet and many things. So that becomes very difficult even for them.
Mechanism is again
Yes.
provided a window is open for a week
for a
or.
small period.
No, my lord, for a week, my lord, there was a petition in the High Court also where we pointed out that why for a week? Because most of the students who have no grievance, this is to be linked with other examinations based upon which, my lord, these marks are to be considered. So that cannot be postponed. We cannot postpone those examinations, my lord, IITs, etc., etc. Therefore, we compressed.
No, we are not seeking any.
Except that the window which was open for 1 week, where 1 lakh plus some students availed the benefit. That window may be reopened.
No,
for
that
another
may not be possible. I'm right now saying, but I'll place it on record, my lord, by Monday. Because 1 week decision was, my lord, a conscious decision, keeping, my lord, several consequential steps in mind.
I have been receiving, my lord, messages through
And yes,
from
my lord, my lord,
many
that will be
students that they
perhaps-
have applied and not received the answer sheet also. They are still pending. They don't even have their answer sheet. So what my learned friend is saying that 1.68
lord,
lakh
everyone
students,
who
they may have
applied
applied,
well-
but this is a very small number. That's a very, some time may be provided, my lord, for them. What you wanted, that's okay.
Sir, please look into this.
Yes, my lord. My lord, I'm not taking this as an adversarial litigation, my lord. But it seems, they seems to have missed that deadline, my lord. I don't think so. Anyway, my lord, I'll place that on.
It's not that we have missed it. The fact is that, my lord, lot of students.
No,
have
not missed.
the answer
You
sheet
see,
also.
missed.
Sir,
Yes.
let the response come
Will.
and you file your rejoinder.
Yes, my lord.
Indicating all the categories of cases which require attention.
Yes, my lord.
There will be one category, as you say, who have responded but have not been supplied documents.
Yes, ma'am.
There may be other categories who, because of infrastructural or technological deficiencies, were not able to access within that
Yes, my lord.
small window. So give that response so that the solicitor and the union can adequately address the issue.
And my lord, with some details, because many students could not do it, may not be.
No, we'll give specific numbers of the student name and other details.
File on Monday, then we take up on Tuesday.
Yes, my lord, we can file it on Monday.
Whatever date is convenient to my lords. Whatever.
Either Tuesday or it will go 1st September, tell us, whatever.
I put it in the hands of the court. Whatever date is convenient, my lord may take it.
See, at least you'll get some solution after.
Yes,
this.
yes.
You're talking about career of students for this year, for
Yes.
admission.
Well, it's counter affidavit we filed by Monday, post this matter on Tuesday.
Please allow.
I'm allowed.
No, this is a section 11 petition, Lords. The section 11 petition for appointment of an arbitrator. On the last date, your lordships have directed us to serve them through the council. My lords, we have done that, my lords. And they have been appearing before the Delhi High Court in the section 9 petition.
Petitioners are from island, respondents live in Delhi in island. Most of them is about to show.
The local council.
We have done that, Malaj. The report is there, Malaj. We have done that on 23rd of July, Malaj. I'm sorry, Malaj.
The respondent is in Gautam Buddha Nagar. The petitioner.
Arbitration to take place in Delhi or Gautam Buddha?
It can take place in Delhi, Malaj. A retired judge of Delhi High Court or any other High Court can be appointed.
All right, we'll appoint someone.
Grateful. Obliged. Please,
My lords, in item 4, there has been some development. Yesterday, we received an email from the respondent that they are willing to pay some part payment and have assured to resolve the issue. So let's take a chance probably. And we shall of course accept it without prejudice. My lord may have it after.
Lords, on a joint request, may have it after some time, Lords.
That settlement talks are going on. What's the matter for?
So request if my lord would say that they've written an email to us and we are accepting the
Lords,
amount.
I do not have any instructions per se.
So they have actually written an email.
Written,
not say
the only
anything
instruction
because
that I have.
Grateful.
Obliged.
Your Lordship, in item number 5, Your Lordship is directed on the last date of hearing to serve respondent number 1 and 3 through Ministry of External Affairs.
This for respondent number 3, my lords. I have entered appearance, my lords. I'm requesting for a short time, my lords, to put my response, my lords, on record.
For respondent number?
I'm for respondent number 3, my lords. It's a consortium of the petitioner and these 3 respondents, my lords.
Council for respondent 3, 6 and grant.
Already given.
2 weeks.
Your Lordship, also please note that for respondent number 1, we tried to service them, but it came back. And now there's a requirement for model form, and that also we have done. So we are awaiting confirmation for service for respondent number 1.
Service on respondent number 1 is still awaited.
And R2 has been served. R2 has been served. Respondent number 2 has been served.
And for respondent number 3, my lords, I have entered the appearance. I'm requesting for a short time to, my lords, file my response.
Respondent 2 is complete. As regards respondent number 1, this is still awaited. The petitioner, so the petitioner may would like to serve the respondent number 1 through substituted service.
So for respondent number 1, we are not able to service so far because there was some requirement.
That's why we are saying that if you want to serve that respondent through substituted service, you can do it. It will expedite.
They can wait for the, my lords, because the office report says that the model form has been provided. Now they are just awaiting the service. Let's may, that may not be required because I may be given 4 weeks time to file my response for respondent number 3.
We are granted.
I'm highly.
3 weeks, all right.
Highly obliged. 3 weeks.
There is a problem in that.
Well, in this, there is a problem in service. Because we've been trying to serve them, but the addresses have changed. Even the law firm which responded to the notice from Bangladesh, that has also said that we are not aware of their whereabouts. So we have sent them an email yesterday, we have found some new email addresses. I'll file the affidavit to that effect. Have it.
As per the office report, the respondent number 1 could not be, has not been served. Then counsel for the petitioner seeks and granted 1 week time to furnish another address.
File, we'll file another, we have served them through email.
So I found an email.
Because earlier emails were also bouncing.
Petitioner may meanwhile serve the respondent through email address.
Grateful.
In item 7, my lords, there's only one respondent. We served them through email and WhatsApp and a local courier. Through email and WhatsApp, it has been served, but with courier service, it has been returned back. I only request that 3 weeks may be granted to me to serve again through Hague Convention model form. We will try our best, my lords, to bring them the court.
Follow me that, as the office report says that you did not take any steps to.
My lords, we actually, thought that, they will appear through email only. But when they have not appeared, we thought that, we should exercise our rights under the Hague Convention.
Take these steps so that,
My lords, I will take the Hague Convention.
as per the office report, petitioner has not taken steps for issuance of show cause notice as per Hague Convention on private international law. Consequently, the petitioner undertakes to do the needful within 1 week. Post the matter pursuant to await service.
Highly obliged.
It's an item 8, letter has been circulated. Greatly obliged.
Item 9, my lord, is a very, very serious issue of
Can I have a little
corporate
time?
loot of tens of thousands of crores
Very well.
by way of the KG gas basin, gas fields, which has been
After-
allowed by successive governments. The earlier government, this contract was signed during the earlier government. They allowed it, and now it is still being allowed. And we had, there are several.
We ought to take it up on 7 September.
In fact, the government of
But after
India must be
20
asked to file an updated status report as to what has happened subsequently. Because the last order is of 2015. After that, the
2018.
matter has not been listed.
After 2018, nobody has
That's
heard
right.
about this petition.
So let me
They have
update your
I
lordship.
know, my lord, unfortunately, from our side also, many of these petitions go under the.
Listing down in non-miscellaneous days. So that it can be taken.
In the meantime, your lordship may ask the government to file an updated
you don't need
status
to ask, we
report
will
as
do
to
that.
what has happened.
We will do that on our own.
They will do it.
My lords, item number 9, writ petition 513 of 2013. I'm hearing for petition number 1.
9 is what, this is item 10.
So item number 9, we are here for petitioner number 1.
Non-miscellaneous date, isn't it?
Okay.
My lord, item number 10, there's nothing survives in this petition. It was 213 petition, it is infructuous. My lord can dispose of being infructuous.
Ms. Pragya Baghel, Secretary of the Supreme Court Bar Association, state that the matter has been in practice. Disposed of report.
Lordship, in this matter, item 11, Lordship on 6th April 2015 has granted bail and he is released from jail. Lordship may make this order absolute till his premature release application is decided. Let this order continue and Lordship will dispose of the.
Of the matter. Yes. So the petitioner was a live convict. Has approached this court seeking a direction for his premature release. This court granted him interim bail on 6th April 2015. However, it seems that no decision has been taken so far on the petitioner's prayer for premature release. Consequently, we dispose of this petition with a direction to the state of Uttar Pradesh and its authorities to take an appropriate decision on the petitioner's request for premature release, as per the government policy, rules, within a period of 4 months, the petitioner shall continue on bail till an appropriate decision on his application for premature release is taken.
Lord, highly obliged.
Solid management due to
So he was those days being.
कर दीजिए, close कर दीजिए.
Initiated in the year 2019 when unfortunate death of a child due to dengue that the suicide of the parent, his parents was, the parents was brought to the notice, was reported.
Directions were issued with regard to solid management. If the cantonment board had. You are in 12?
No.
Next. The cantonment board had planned the plan of action on 1/4/2019. Somebody is there?
Virtual mallet.
Somebody is online.
Yes, madam, are you appearing in this matter?
Unmute yourself.
Because I appear for Delhi cantonment mode, the lordships had called for an action taken plan from all the authorities in Delhi, my lords. We filed it, but now because it's come in 26, we had filed it in 19, my lords. Much has changed. We may have to place a fresh plan, my lords. This is because some child had died due to dengue, my lords.
You are appearing for whom?
Delhi cantonment board.
Alright, Council for the Delhi Cantonment Board state that the direction regarding action taken, submission of action taken report were complied with, and the authorities are conscious of their responsibility and shall continue to take necessary preventive measures in future as well. In view of this undertaking, the trustees are closed.
Your worship, in 13.1, a letter has been circulated for adjournment.
Recent policy. There's nothing said.
Lordships are granting some time in this. Item 13, Lordships are calling it after some time.
Somebody wants an adjournment.
Yes, my lords.
Grateful.
Grateful.
Item 14
14 is, no, it's not infructuous because there were two issues raised in this case. One was regarding payment of compensation for delayed payment of wages under the old Narega Act. And the second was giving of minimum wages which are prescribed by the states rather than this wage prescribed by the then Act. So under the new Act, this VG.
Scheme itself is now replaced by.
Yes, and even under the new Act.
Manrega is not there anymore.
Yes, but under the new Act, it refers to Manrega regarding payment of minimum wages. So we are saying that this court has laid down in a very large number of cases that minimum wages notified by the states have to be paid, otherwise it is forced labor, otherwise it is like bonded labor. And therefore the issue will still survive under the new Act as to whether the minimum wages notified by the states have to be paid.
For you under the.
Yes.
You can challenge the new provision if so required. Or you will seek some direction.
We can. It is open to us to do so, but what I am saying is.
This scheme was introduced, Manrega.
Yes.
Those people who know the rural life, they had really appreciated it because there were thousands and million people who had no source of livelihood.
Correct.
So with a view to provide a very respectful manner of earning livelihood.
Correct.
That you will work and then you will earn.
Right.
Now, because the scheme was such a comprehensive scheme to provide everyone in the village.
Yes.
So the principle of minimum back wages may be a realistic approach knowing the object of the scheme at that time. But in any case, in a PIL, it will be very difficult because unless some individuals come claim who are the persons who are entitled to, were they satisfied, nobody.
That is very clear because the government had been paying them the floor minimum which was notified under the Act, under the earlier Act. Now that floor minimum is much less or considerably less in many states than the state minimum wages. And your lordship have held in a large number of cases that the state minimum wage represents the absolute minimum wages that can be given otherwise it will amount to forced labor. So therefore, now the new act which has come, actually all that is recorded as to how much has been paid.
This Manrega scheme
Yes.
should be implemented on pan-India basis because it was not being given operational, it was not made operational in some of the parts at that time.
Implementation was not proper.
And it did a wonderful job in the rural areas. It was a very salutary scheme as such, a good effective welfare scheme.
Yes.
Which did not, it was neither a freebie kind of scheme,
Yes.
nor it was a case of exploitation also, because people in the, see the minimum basic concept in a particular village where you are living in your own home, you go to the farm, you go to the road being constructed or water supply drainage system is being constructed, going there earning livelihood, that wages will have to be seen consummate to the local conditions.
That's why,
Notified.
that is why your lordship has said in not one, not two, three cases, three judgments.
So far as farm labor is concerned.
Yes.
Minimum Wages Act was not notified.
No, in fact,
It's not an umbrella for all forms of work.
no, my lord. In fact, your lordship has have held that no person, no worker, rural, urban, anybody can be paid less than the state notified minimum wages.
It is not an umbrella which across the board, because there was cases with regard to hard labor in prisons.
Yes.
The
Anyway,
question-
what I am requesting is
question
that your
arose
lordship
was
may
whether
list it so that
minimum wages will be given or not.
there are two live issues. One is the payment of.
Withdraw this petition if you feel the new.
No, Lord, the first two prayers, which is regarding delayed compensation for delayed payment of wages, they have not been paid still. And therefore, even under the old act, those delayed payment has to be given. In fact, my lord, in another case, this court, in that Swaraj Abhiyan case, had directed that those payments should be made. Unfortunately, still those payments have not been made.
Even
So
with-
therefore,
with regard to that prayer, persons before us are some public spirited persons.
yes.
They are not the individual affected.
Yes, of
Now,
course.
whom to pay that compensation, again, because we are taking up today after 11 years.
Yes.
It will become again a virtually impossible and unmanageable direction to whom to pay.
That's very easy, my lord, because everything is recorded on a computer as to how much, who was paid, for which month, when he was paid, how much he was paid. Everything is recorded on the computer. And therefore, my lord, and the act itself prescribes that if it is delayed, then you have to pay compensation for delayed payment. But unfortunately, that was not paid. And therefore, that will have to be determined. And secondly, your lordship will have to consider as to whether even under this new act, where they have said that we will prescribe a floor minimum, etc., under this act.
So we will not see into this matter. Therefore, that some petition will come and definitely will come in.
No, because this, the new act refers to the old act. New act says that the floor minimum cannot be less than what is prescribed under the old act.
Maybe, but
Section 6.
If there can be two possibilities, because at least I have not seen the new act.
Yes.
Under the new act, one, that if they have given a guarantee and it is not being implemented, the nature of relief will be different. But if there is suppose no guarantee, then you might find that a provision itself requires to be read down or to be judicially.
No, there is a guarantee. The only what they have done is they have now said that half the funds will be paid by the states. Unfortunately, my lord, now what has happened is since this new act has come, the amount of employment under this act has fallen to half countrywide for the whole country. That is because, my lord, state governments don't have the money. They are unable to provide the funds, etc. This is what is happening. But apart from that, we are on this question of what would be the minimum wages payable under this new act. This new act says some floor minimum will be notified, but that floor minimum cannot be less than what is provided in section 6 of the old act. Now, if your lordship agrees,
you will have to file a petition under pointing out the scheme of the new act.
yes. No, we can do that. I'm not saying that we can't do that. I'm saying that your lordship can examine this question and determine it in this very petition itself.
Now, in this
That-
question, it was possible.
Because otherwise what happens is, my lord, these acts keep changing from time to time, and unfortunately, because of the time that it takes for petitions to get decided sometimes in this court, the petitions that way become infructuous.
They do.
So that is,
Take the
that,
necessary measures.
pardon, Lord?
You have to take the necessary measures. We
Yes.
understand that because of pendency of this matter, this question
We
has
keep
become
trying,
stale.
Lord, we keep mentioning sometimes,
No,
unfortunately.
you know, and we understand your concern and your agony there.
Yeah.
But what we say, the remedy is not to give life to this issue in this petition, but to give you
But
the
it
leave
can
to
be-
file a fresh petition.
If it can be dealt with in this petition also, the issue of minimum wages. So the issue is common. The issue is whether the act can prescribe a wage which is below the minimum wages prescribed by the states. And my lord, this issue has been decided by this court in many cases, that no act can prescribe or nobody can be paid less than the minimum wages prescribed by the states.
The problem here is the basis of your earlier writ petition having been taken away. You can file a fresh one pointing out, in fact, the up-to-date data statistics.
can. I'm not saying that I can't.
Not getting which state is delaying it, where is the problem, all that you can.
Lord, I can.
No,
I'm
Swaraj
saying
Abhiyan has dealt
this is
with
a
all.
purely legal issue. And this purely legal issue can be decided because the new act refers to section 6 of the old act.
Without statistics being there as on today, it's not possible to decide the old one. No, it's better to have a fresh detail, fresh statistics under the new scheme
And
also.
Lord, but unfortunately what happens is by the time the new petition reply, this, that and the other, so much time is elapsed.
Problem has been arising, and then because that's why it requires a very vigorous follow-up. Once you issue notice without fixing a date, then this is what it happens.
Your lordship is right.
With this new introduction of the system of that, at least a date is fixed now. At least matters are in cycle.
So just see, my lord, this is what is the difference between what is prescribed and the state minimum in the wages. And just see the meager wages being paid under the 300 rupees, etc. Mostly 300. 300 is being paid per day as the wage under this Narega. And in most of these states, my lord, the wages prescribed are considerably. That their desperation to accept.
Mr. Bhushan, the Constitution does not make right to work a fundamental right.
In fact,
it is more in democratic aspiration under Part 4. To achieve that aspiration, the state formulates policy where work is provided at a graded compensatory level. Should we treat it on par with Article 18 beggar? That is a very big question which we need to answer, because if we do that, the state contracts its social welfare activities can we issue a mandamus upon them and say that no, you have to implement Manrega or VG Ram
So firstly, my lord, my response to your lordship.
the money purse string.
Firstly, my lord, my response to what your lordship just said is that the time has come when this court said that dignified life is one part of Article 21 rights. So in my respectful submission, my lord, dignified life requires you to at least get employment at minimum wages. That's the first requirement of.
If we put minimum wages as a threshold,
Yes.
then employment shrinks. You realize the difficulty.
No,
When
there is
the
no difficulty. In
minimum
fact,
wages threshold is put,
in fact,
the net of employment will shrink.
in fact, my lord,
Because the
this
size of the cake
I understand.
remains the same.
I understand. This
If you
argument
take a
has
big
been.
bite, you get 2 bites. If you get small
This
bite, you
argument
get
has
10
been
bites.
made. This argument has been made and rejected by this court, my lord. Exactly this argument. It says, if this be the correct position of law, it is difficult to see how the constitutional validity of the Exemption Act, insofar as it excludes the applicability of Minimum Wages Act to the workmen employed in famine relief works, can be sustained. Article 23, as pointed out above, mandates that no person shall be required or permitted to provide labor or service to another or on payment less than the minimum wage. And if by the Exemption Act, by excluding the applicability of the Minimum Wages Act, provides that minimum wage may not be paid to a workman employed in any famine relief work, it would clearly be violative of Article 23. Clear pronunciation on this very issue. Here it was famine relief works. Now we are talking about rural employment under this Rural Employment Guarantee Act. Therefore, my lord, this issue is a very important issue, which in my view, my lord,
So,
has been settled.
Again, nature of activity to which
Yes.
the persons under the Manrega or the new law
Yes.
or the new policy are employed.
Yes.
If they are employed in areas
Yes.
which do not fall within the ambit of the state working as an industry or a notified activity under the Minimum Wages Act,
Yes.
the Minimum Wages Act umbrella will not extend. We are wholly with you that we must give liberal interpretation to these social legislations.
That's why I'm saying, my lord, your lordship may
Let
not.
us examine it in the light of the new law, Mr. Bhushan.
Lord,
We're not averse to
I
examining
can
it.
do that.
Not in the architecture of Manrega.
He can withdraw and come.
That's because, my lord, the new act refers to Manrega. It says
It may refer to Manrega as
the
a-
minimum wage
as a
section.
relevant prior policy. But the requirement of constitutional adjudication will be under the new law.
This issue is
If your
covered
lordship
Swaraj
would-
Abhiyan, the judgment has already been delivered. You may examine that. You
Yes.
were only appearing in that case also.
That has been.
Aruna Rai's case is also dealt with in Swaraj Abhiyan. Now this is a repetition of that very judgment.
No.
Yeah, the same issue is the delay in payment of wages is what was considered in that
Your
also.
lordship is right. Your lordship is right. But unfortunately, even
If there
that.
are any left out parameters of that, that's another thing for you to consider. This
saying that-
way, this cannot continue this.
So there are two aspects. One is the aspect of payment of delayed payment compensation.
Yes.
Now your lordship is right that was referred to in the Swaraj Abhiyan case, and they had said
Four
that.
judgments, food security, Manrega, all of them were considered in that judgment.
Yes, your lordship is absolutely right. But unfortunately, despite that judgment, unfortunately, that delayed wage payment has not been made to these workers.
It's another angle. This is a writ which was filed before that. So therefore, this stands covered by this judgment. If there is any problem in implementation of that, that's another cause of action
All
for
right,
you.
all right. So
This
your
cannot
lordship may
continue.
exclude that.
Yes.
But on the issue, on the prayer CD, which is about minimum wages, whether these workers can be paid less than the state notified minimum wage, that issue remains live for the reason that the new act also says
this, maybe you can file a fresh under the new act if
New
you
act.
have problem in implementation.
If your lordship wants, we'll file a fresh. It's all right. I can
But,
file a fresh.
Mr. Bhushan, it will give a new comprehensive.
Yes. Up-to-date picture.
Scheme of the
All right.
new act and
Very well.
SPT
Your
policy.
lordship feels that I should do that.
We'll dispose of this in light of Savraj.
Yes.
Being replaced by.
We'll take into account what was said, what has happened.
The issue with respect to implementation of that Manrega, Purana Viva Mahatma Gandhi Swansu Act,
Yes.
2005, has been effectively dealt with by this court.
Yes, Swaraj
Has
Abhiyan.
been
That's
effectively
citation.
answered by this court in
Swaraj Abhiyan,
in
citation.
Swaraj Abhiyan,
Yes.
612,
Give the citation. Union of India.
reported as also. We may also hasten to add that the Manrega 2005 has now been replaced by a new legislation, VB Ramji Act,
G Ramji.
G Ramji Act of 2025 or 26, देख लेना पक्का, 23 का Swansu Act. We therefore dispose of this petition.
I mean, I can also amend this petition. Either way, I can amend this petition.
Better file a fresh petition.
All right.
Dispose of this petition in light of the decision in Swaraj Abhiyan with liberty to the petitioners to file an appropriate petition with respect to the statutory scheme as contained in the new act.
Including the issue of minimum wages and delayed payment.
Fresh petition, including on the issue of grant of minimum wages under the so-and-so new act.
And delayed payment compensation. Because
Liberty is
that,
you can raise all the questions.
that is not in the new act. That is true. That would be under the old act.
So, Tulka, my sister.
My lord, we have, my lord, paid for the other side, we have no objection.
Anyway, I and my brother will take care of it.
That's it.
Does it still survive otherwise?
That's just, my lord.
All right.
Right.
Then
Madam, may I have a brief note, my lord?
Well, as there is one rate and there are six SLPs also, Malas.
Six SLPs.
They're all.
15.1 to 15.6.
today then we have listed it for a short.
That's right.
Limited purpose.
Please.
Actually, people and senior counsel points out that the matter still survives on merits. He has handed over a brief note which is taken on report. Post this matter along with the PG.
They're all listed today.
They are listed. All these.
Well,
matters are-
permit us liberty to serve the unserved respondents in the SLPs.
We post these matters on so and so date. Meanwhile, the unserved respondents we also say.
Grateful.
Well, may I also hand over what need to be done in this matter? Is it tabulated format?
Has placed on the court a brief note with respect to the action that are still required to be taken.
A tabulated chart. So grateful.
Thank you.
That I'm not there.
Huh?
Grateful, Manas.
So grateful.
Item 16 and 61, we will take up after Sabrimala's pronouncement.
Your lordship, this matter has become infructuous. It has become infructuous.
Oh, Acha, you
I already done, sir.
Counsel for the petitioner state that the matters have been rendered infructuous, disposed of.
Deeply obliged.
Item 17. Please, Malas. Your Lordship, this is a serious case of misuse of powers by special executive magistrates, Malas, all over India, Malas. It's a small convenience note that I have made, Malas, and I would like to circulate this, Malas, for your Lordship's convenience, Malas.
All these issues may not survey because BNSS have come. This,
Yes.
your challenge was CRPC.
No,
So the basis.
Malas, with the new act, it has gone even more serious than it was in CRPC, Malas, and I'll show it to your Lordship's, Malas. I'll show it to your lordships. If your lordships would have a comparative analysis, my lords, with section,
Won't we be required to file a fresh petition of challenging the new act's provision?
my lords, it is more or less the same. It is more.
But then this act has
If you're-
to repeal.
No, if your lordships would only give me 5 minutes, I'll just want to do a small comparative between CRPC and BNNS.
We are not concerned with
Only on section 20, my lords.
declare provisions of a repealed act ultra vires. Ultimately, your belief will be
Yes, ma'am.
against the corresponding provisions of BNSS.
Absolutely, yes.
Being 107 to 110 of CRPC.
Yes.
They're only pointing out where
Please
get the.
file a fresh application on that score.
I'll file a fresh application.
File a fresh application.
I'll file a fresh application.
The petitioning person seeks a permission to withdraw the petition with liberty to file a fresh petition in challenge to the provision of Bharatiya Nagrik Surakshita Sanhita 2023.
Some challenges are already pending.
Pending out.
The new BNSS challenge.
BNSS.
These are known as chapter cases that go, even 145 proceedings go before the executive magistrate. And
He
there's,
says-
and there is rampant corruption. I must tell my lord, there is rampant corruption.
Raju, if you go back to 1898, it's an evolving concept because earlier the executive magistrate had much more power of adjudication. Then 73 Act took away those powers, but security proceedings were kept with the executive magistrate, including small proceedings of possession. So
And
like
145 is the most dangerous one, which is not there in the petition. 145 leads to rampant corruption, civil suits are hijacked, and entire proceedings are conducted before executive magistrate.
What about 144?
144 is
144. That's the most fertile jurisdiction for lawyers as well as all stakeholders. Police का पैसा सर कैसे?
There's a change in system. In
Because of with liberty to file.
in fact, the Bombay High Court said 7 days, but the law says only 24 hours you can be confined under 151. There was a Bombay, the Delhi High Court, when it says 7 days, is probably not correct.
Not correct. But
Grateful.
It's covered by that. Limits in.
Because.
So the issue raised in this petition has already been answered by this court by judgment dated 6th May 2024. Rendered in petition civil number 251 of 2016. In bracket parties name Karuna, Abhimeet Sinha and others versus High Court of Judicature at Party. The petition disposed of in.
Item 19, my lord. Two
I
young
appear
boys
for Bar
approached this
Council of
honorable
India.
court, 21-year-old.
Your Lordship, this
done.
matter was filed in 26.
No longer there.
Because of this intervention, had my lords not intervened, or any person who is over 3rd March 2017, my lord. And I
Your
must
Lord-
point out one more heartening
Your
thing.
Lordship,
Both
if your
the boys
Lordship
who were
still have it
petitioners, my
after
lord,
2 weeks.
completed their law degree from CLC and Jindal respectively. They're now practicing in Punjab and Delhi and have a thriving practice. Both the young boys, my lord. They were 21 years old when they came to this court.
Your Lordship, this
My lord, my
matter is
only
coming up
request is
after
one,
a
my
long
lord, if my lord
time.
would consider.
The writ petition was filed. Your
Yes, Madam
Lordship, the writ
Radhika.
petition was filed in 16 and after 23, it's coming up for the first time. I will trace out the developments. Give me 2 weeks. I'll file a fresh affidavit and then your
Before
Lordships
that,
may decide.
may I
it.
only point
Your
out one
Lordship
thing, my
stay is
lord?
being implemented meanwhile. It is not that anybody is being denied admission based on age.
I'm not on that, but my only request is in 2013, Bar Council by its own notification at page 77 says this clause 28 is constitutionally obnoxious, fundamental right is affected, gross violation. In 2016, complete volte-face and this maximum age limit is reintroduced. My lord, because this misadventure does not happen again, my lords may want to lay down some guidelines. Because it is not even
All I'm
traceable to the
asking
power
for is
under
2
the
weeks, Your
Advocates
Lordship. I'll
Act.
file an
My lord,
affidavit
legal
and then we
standard
will
has
address Your
nothing to do with the
Lordships.
max.
The matter was lying cold for 3 years.
By the rule
By-
itself being declared unconstitutional. That illegality, that there cannot be an age bar.
That's right, my lord. My lord, education can be acquired at any age. Then the interim order may be made absolute and the petition can be
Your
disposed of.
Lordships may have it after 2 weeks. I will file my affidavit, Your Lordships, and let me trace out the developments, if any, and place it
This is
before
what
Your
worries me,
Lordships.
my lord, because this misadventure continues in some way or the other of
Lordships,
reintroducing.
I'm only asking.
Anyway, the embargo is not there. The stay will have to be made absolute. What is there pending? In the
Your Lordship,
2019,
we
you have
may
not
have to-
reintroduced it. On
Your
12th
Lordship-
March, you have not reintroduced it.
And
Your
I must
Lordships
point
had
out, my
stayed our
lord,
circular. After that, we have not implemented that circular. Your Lordship
they
may have
can't.
it in 2 weeks. I'll file
Can
an
be recorded
affidavit.
and
Maybe
it can be
they.
disposed of.
Has now been withdrawn.
Explicitly. My lord, they must give that statement. They have, this court on 3rd March 2017.
I'm not saying it's withdrawn. I'm only asking time to file an affidavit. It's been stayed, is what I'm saying.
It is stayed, therefore it requires some sort of
Adjudication.
adjudication.
I'm saying have it after 2 weeks.
It after 10 days or so, please find out and.
I
better
will, Your
withdraw
Lordship. I will, Your Lordship. I'll
If
file
you have not
whatever
formally withdrawn,
instructions
then
are.
you withdraw your circular.
I will, Your Lordship. I will. Obliged.
And counsel for the Bar Council of India seeks and grant you time to have instruction for withdrawal of the interim circular.
Grateful, my lord.
Admission in MBBS, sir. Years are over.
Item 20, admissions were made.
Technically, this matter has become infructuous because matter was relating 17-18.
17.
The matter pertains to admission to MBBS course for 2017-18 and 2018-19. Interim directions were issued, and with the passage of time, the case has become rendered infructuous. Disposed of. This
Again, same, sir. Mandatory application need.
Item number 21, I am appealing for the respondent number 4, Rajiv Gandhi of Health Sciences. You see, the issue involved in this petition has already been settled by this court in number of cases. If the students' admission cannot be treated private unaided professional school without qualifying need. So it is settled in number of cases. It may be dismissed.
The issue pertains to admission in dental colleges pursuant to NEET 2017. With the passage of time, the issue has become fractious. The petition disposed of upon.
Proceed dismissing this.
Then has been decided in Akbal bin Azhar versus Raj.
Citation.
Citation given. Supply the citation.
So is using this now? Hello.
Done. This is case management of original suits.
The rules have been formed.
Delhi High Court originally said rules have been.
Notified. These auto proceedings have been rendered infructuous in view of the subsequent events, namely formulation of Delhi High Court in bracket original style rules 2018. Disposed of as infructuous.
Please, my lord. Under the writ petition, your lordship may just see the order of 2022, 10th of November 2022 order, my lord. They gave a specific undertaking to this honorable court.
Oxygen.
Now, nothing survives, my lords. The guidelines have already been published, my lords.
But they have not filed it here, my lord. We don't know. My lordship may just see the order of 10th of November
Well, as I record my statement, I'll give the details of the guidelines.
They took the time to file it.
Well, let's,
Do you have copy of the guideline?
well, let's, we'll just get it. We don't have the printout. We'll get the copies, Malas.
We will take the record and dispose the.
Very well, very well.
My lord, my respectful submission is, my lord, Lordship may just have seen the order of 2022, my lord. Now we are already 10 years have passed, my lord, from the filing of the writ petition and 4 years from the passing of this
They
order.
have published the rules, they are saying. They're just placing it on record
Yes,
after
yes.
Passover is what they are saying.
Please, my lord, let them place it on record.
You are appearing for the union.
Yes, my lords, we have framed the policy. I'm sorry, we are not carrying printouts.
As we have an additional solicitor of India states that in compliance to order dated 10th November 2022, National Oxygen Guidelines and SOPs for optimal utilization of medical oxygen equipments and devices have already been notified.
Yes, my lords.
A copy thereof be placed on record.
Please, my lords.
In this view of the matter, it goes without, it goes without saying that the authorities on on pan-India basis shall meticulously comply with those guidelines.
Lordships.
The petition is accordingly disposed of in above terms.
Grateful, my lords.
But give us the guidelines.
My lords, we'll just file it, my lords. And I'll give a soft copy to my colleague right away.
We file it by tomorrow with affidavit.
No, just give it to the evidence.
Already done.
So item 24, my lords. As far as the individual colleges are concerned, my lords, the grievances are redressed, my lords. But your lordships wanted to address a larger issue, my lords. Your lordship may have your lordship's order of 19th of September 2018, my lords. Because this was a recurring issue at that point of time, my lords. So therefore, your lordships wanted to address that larger issue.
That is now infructuous. Issues have become infructuous or stale.
My lords, last order, the medical council, the council for the medical council said the report will be filed before this court as per this last.
This can be disposed of. The council for NMC are saying they are newly engaged, but otherwise your lordships have taken note of the issues, my lords. And this is admission 2017-18 batch. But if your lordship see order of 14 January 2020, Mr. Gaurav Sharma had appeared and wanted to furnish a report on the working of the system that is installed. So the system has been installed by NMC in pursuance of the directions of your lordships.
No, my lords, system, what they meant is, my lords, 10th of September 2018, your lordships had passed a detailed order, my lords.
Technological interventions essentially in the system. If your lordships wish to examine it, they'll have to file a fresh status report, but otherwise this can be disposed of.
In fact, Mr. Sibal was appointed as the amicus curiae, my lords. Mr. Sibal was appointed as the amicus curiae, was assisting the court, my lords, in that. And it went on for considerable time, my lords.
No issue survives as such.
If your lordships want to examine that report only, my lords, otherwise your lordship can dispose it of.
Dispose it of as of now. The admissions have been going for the subsequent academic years. There may be individual grievances, but large scale deficiencies have not been noticed by us.
Yes.
So this petition can be closed. In the event in future some issue arises, we will take a fresh look.
The matter pertains to admission to MBBS course for the academic year 2017-18. Various directions, interim directions have been issued from time to time. It seems to us that in due course of time, the matter has become fructuous. The larger issues
May be addressed as and when